Greetings on this day, July 3rd, 2019. My name is Marick Masters, Director of Labor at Wayne, which includes the Doug Fraser Center for Workplace Issues. I am also a professor of business at Wayne State University. I am starting a bi-weekly webcast on issues pertaining to labor in the workplace. I begin with a disclaimer that the views expressed here are my own and not those of Wayne State University. These webcasts are intended to inform about current topics on issues affecting workers and their workplaces. In these webcasts, I take a point-counterpoint view to encourage debate and discussion about controversial matters. I pose questions for future discussion. Today's topic is the recent vote at the Chattanooga, Tennessee Volkswagen plant among 1,700 workers considering representation by the United Auto Workers Local Union Number 42. The union lost the election by a 29-vote margin, with 93% of the eligible workers participating. I want to trace the rather convoluted events leading up to this vote, present both sides' arguments, and discuss proposals for labor law reform. The genesis of the June 2019 vote on union representation dates to February 2014, when the United Auto Workers lost another close vote to represent the production and maintenance workers at the same VW plant in Chattanooga. The auto workers alleged unfair interference by various outside forces to influence workers against the union. In December 2015, the Auto Workers Local won an election to represent 162 maintenance or skilled trades workers, part of the same group of the larger group that voted before. It is reported that Volkswagen stonewalled bargaining with the union and challenged its legitimacy, arguing that the appropriate unit for representation had to include both production and maintenance workers. No progress was made for years on the bargaining front, so the auto workers on April 9, 2019 petitioned for another election to include both the production and maintenance workers, as Volkswagen had previously sought. Volkswagen asked that the National Labor Relations Board dismiss the petition on the grounds that it was untimely, which the board proceeded to do on May 22nd of this year. The auto workers shortly thereafter filed another petition to hold an election, which was granted. It is reported that the auto workers' petition was accompanied with a supermajority of authorization cards among the proposed bargaining unit production and maintenance workers. During the period between early April and the election in mid-June, the company took several steps to persuade workers to vote against the auto workers. According to various media reports, Volkswagen engaged in the following: retaining a well-known union-busting consulting firm to provide advice during the election campaign period, using legal objections before the National Labor Relations Board to delay the election from late April to mid-June to gain time to influence workers to vote no on union representation, holding captive audience mandatory attendance meetings in which workers were given strong anti-union messages, requiring workers to attend a meeting in which the state's governor made comments arguably against union representation, playing good cop, bad cop, and taking popular steps to influence workers to vote against the United Auto Workers, including firing an unpopular plant manager. On top of this, various outside groups campaigned aggressively against the United Auto Workers. The company, on the other hand, would argue that it provides good jobs in a region where they are sorely needed, that Volkswagen remained nominally neutral in the campaign, and that the company has every legal right to get its message across to workers and report the record on union representation, warts and all. In this context, several issues merit discussion by policymakers and practitioners in the field of employment and labor relations. Specifically, what rights should employers have to participate in union certification campaigns? Should they have the right to hold so-called captive audience meetings? Should employers be able to change working conditions in the middle of a campaign, which lends the appearance of trying to buy votes? Should high-ranking officials be given access to workers in election campaigns to make a case against the union? These are just a few of the relevant questions that arise. Interestingly, there is legislation pending before Congress to take some action on these matters. Representative Bobby Scott and Senator Patty Murray have introduced legislation called the Protecting the Right to Organize Act, the so-called PRO Act of 2019. It would prohibit captive audience speeches and facilitate the negotiation of first contracts, as the United Auto Workers Local 42 and Volkswagen were unable to do after the maintenance workers were certified in 2015. We hope this legislative proposal will stimulate debate about the adequacy of current labor law in protecting workers' right to unionize. It deserves a fair hearing in the House and Senate. I look forward to hearing your comments on this webcast. You can email me at Marick, M-A-R-I-C-K-M, @wayne.edu. Thank you and have a good day.